All right, next on the docket, families of Sandy Hook. The victims, they are still looking for justice more than 5 years after 20 kids and 6 adults were murdered in Newtown, Connecticut. Now, they are suing Remington. That's a company that makes the AR-15 Bushmaker. That is the rifle used in the shooting. They have overcome a federal shield law that insulates gun makers from lawsuits. Now, the lawsuit says the AR-15 is a military weapon. It's marketed as such, and that it makes it negligent for Remington to sell as well as promote. Here, one of the attorneys.
They marketed the weapon for exactly what it was. They used images of soldiers in combat. They used slogans invoking battle and high-pressure missions.
And here an attorney for Remington with its side of the argument.
Advertisements are commercial speech. They involve First Amendment protection. This kind of rifle is owned by millions of Americans all across the country for hunting, target shooting, and home defense purposes.
Now, it didn't stop at Sandy Hook. USA Today says the AR-15 style rifles are now the weapons of choice when it comes to mass killers. Now, they were used at the Texas church massacre, Las Vegas concert shooting, the Pulse nightclub, and of course, as we mentioned, Sandy Hook Elementary School. Now, the Sandy Hook case is now being argued before the Connecticut Supreme Court, this case being widely watched nationwide as it could set a precedent for future cases. And you know, we've had the families, several of them who lost children that day here at the very table. It breaks your heart. Like, I remember all of us in the immediate aftermath of that. And then you just see the cycle. But the one thing that you see of commonality, without obviously the issue of guns and mentally unstable people holding them, is these AR-15s. Time after time, it's part of the lead paragraph that I read getting into the story. But as we've said before in this program, for viewers who've seen, the gun industry has a unique immunity that no other industry has, which shields them from immunity for the product of which they create. But Nick, part of the language that the attorneys were citing was the marketing language itself, which is that these AR-15s have militaristic and assaultive qualities, that they're mission adaptable, the ultimate combat weapons system. How does, if you're taking it from the side of the plaintiff, how do you get across the hurdle that Congress has already immunized these guys, that they can make whatever they want, and in the eyes of Congress and the law, it's the fault of the shooter, not the person who creates the gun that the shooter uses?
Well, there's several ways, and it's a great question. I'm very persuaded by the powerful brief that was filed by several law professors, including Professor Anita Bernstein, a great tort law professor, and they lay it out, how you get around it. What you're talking about is the 2005 Federal Act, the Protection of Lawful Commerce in Arms Act, which creates this really remarkably broad immunity for gun manufacturers. But there are exceptions. There's 6 exceptions, and at least 2 are applicable. One of them is if the sale of this item is in violation of a state law, and they argue that it is, and I can explain that. And then second is, as a common law principle, it amounts to negligent entrustment. So really, let me just take a step back. American common law has always addressed this question. We've always been moving from an agricultural to a industrial manufacturing economy. And from our earliest days, we asked the question of not whether or not you can use an item, use a gun, own a gun. The question is, if it's used improperly, if it's flawed, who pays? Where is the appropriate damages? Who has to bear the cost of a misuse of an inherently dangerous item or product like these guns? And they are inherently dangerous, as you said. The XM15 in the Sandy Hook case shot 154 bullets in 254 seconds. That's inherently dangerous, and it's marketed that way. So should it be the manufacturer who bears the cost if it's misused? Should it be the retailer? Should it be the party who's caused the harm and shot the gun, who in most of these cases is crazy as a loon and dead and doesn't exist on this earth anymore? Or should it be the party that suffers? Right now, the plaintiffs are arguing, well, the only party that really bears the cost in our society is the party that suffers. And a lot of us think that that's not the appropriate circumstance. You can sell a gun, you can buy it, you can use it, but if it's misused, the cost should go someplace else. And that's what these people are arguing.
You know, Doug, you've handled a lot of class action suits, and for me, part of the argument I think that we always have with guns is, and I've gone on screeds on this too many times to count, it becomes too broad. And then, then we get in debates about what the intent of the Second Amendment was. Is it an assault weapons ban? Is it the background checks? Is it whatever else? And then we go into tangents, and then states come up with their own laws, but without something coherent, we never really get to the root of it. To me, I look at what happened with cigarettes, and I look at other industries where once the pocketbook got impacted, and once manufacturers basically look from a CPM standpoint to say, listen, what is it worth for me if I'm going to have to lay out in these legal payments every year if my product is misused? I don't need this in my life. I don't need to be making an AR-15 anymore because it's not worth it for me. That's really how things change. Sure, you can change it legislatively, but when the return on investment from a financial standpoint gets so marginalized it's not worth it anymore, in a lot of ways that'll speed it up more than morality will.
Well, that's true, Rich, but there's another thing also. With those litigations that you're talking about, they started with discovery. And discovery means that you have to turn over the information that you have to the opposing party. In a case like this, if the case proceeds, then the plaintiffs will be entitled to discovery from the defendants, the gun manufacturers. And that's what you're really talking about here.
Just give me an idea, Doug. Some of the things you're talking about discovery is when they did their marketing research, who they were targeting, what language they would target for, what kind of guns they think these people want to get their hands on?
What the internal story is, what they're talking about in the company. If they're actually marketing saying, we are targeting these groups and we want this demographic, we're going after them with these advertisements. We know it could be dangerous. We know people could get hurt, but we want to still sell these guns. That's where the whole thing starts. Remember, with all those other litigations, tobacco and everything, they were unsuccessful at the beginning until the discovery started to come in.
I think you both have put your finger right on the issue. This is not really, as you said, it's not really a Second Amendment question. It's who pays.
Right.
And American law has always, it's taken a while in many cases, but eventually said that the only reason it's profitable and worth selling these assault weapons is because the manufacturer is not bearing the cost of the misuse, which, by the way, for the very dangerous weapons, is predictable, and in fact, it is inherent in the marketing for the items. So it's a question of who pays.
But then you can counter that, and you can look at the automotive industry and say, okay, you buy a Mini, you buy a smart car, it's inherently dangerous when everybody else is driving a vehicle that's 2 or 3 times that size, and when you get hit, you don't sue Mini or Smart, or you don't sue Mercedes for who owns that. You don't also sue Porsche because they clearly market to people who are going to drive fast, and if the speed limit is 65 or 55, you don't need a car that can do 150.
But if you find an automobile that had negligent practices on safety on the design of the car, they knew that they had, a faulty engine or whatever else, we've seen it work. My point is, if we learn that there was misgivings internally that said, guys, we put this thing out here, the lunatics are going to get their hands on this. There's no telling what they do. Or they can adapt this thing with bump stocks or whatever. They'll be able to get off X, Y, and Z. Well, now, all of a sudden, it's a different story.
But the issue is that the gun's doing exactly what it's designed to do, and the Porsche does exactly what it's designed to do. It's not designed to do 75. It's designed to go a lot faster.
I want to save time for our next one because we have all learned the name Roy Moore. And the saga is not just a story of politics. I know everybody's talking about what will or won't happen in Alabama to the former judge who has made a career out of, in my eyes, perverting the law. Now, Moore is facing growing calls to drop out as the nominee for Senate in Alabama. But what I want to do when we come back from the break is look at his history and whether or not he ought to have a future no matter how the politics turn out.